no councils to give any instructions to, but anyway, if any of you want to speak, would you stand, and you could stand to do the pledge? Taking in holds.
Yeah, what you said.
That's okay. Okay, I used the wrong word, pledge. So if you could all sit down, and those who want to speak on behalf of the nominee, would you stand? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God? Yeah, thank you. So I only have two councils here. I will say the instructions now.
I can point that out.
First of all, I would like to introduce the councilors. Councilor Jacobs, Councilor DePaula, Kennedy, Councilor Duff, and Councilor Ferrara. And I will, and I'm going to ask that the councils remain to the very end to hear all of the statements of this nominee. This is a very important day for this nominee. We should show all respect to our position and to this person's special day. So I'm asking all cell phones put away and not used during this very special hearing. So I will start by reading the letter of the governor. And wherever that letter is, thank you. Dear councilors, I am pleased to nominate Carla A. Salvucci to the position of Associate Justice of the Probate Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. So welcome. Before we start, why don't you introduce, you've got a room full of people that come here to support you, so why don't you introduce them all?
I have my witness, Tracy Cohen, who I had the pleasure of working with at the firm in Boston, and my daughter Lila, and my former law partner, Erin Harris, and my daughter Cecilia, my sister Noreen, my sister Danielle Black, my father Fred Salvucci, my son Michael, and my husband Matt Curley.
And you see who's sitting in the governor's chair. Now that's special. So first of all, I will start with your witnesses. So and we'll call on them in the order that you've given them to me. So the first person is Tracy Cohen. She's a former colleague and paralegal at Todd and Weld. Welcome. Okay.
Good afternoon. Many of us are familiar with meeting people through the office who become more than just a coworker or colleague. A few may emerge as your work friends. They're great. They make it a pleasure to go to work each day. But for me, meeting Carla 16 years ago was beyond this. It was a life-changing moment, me hitting the coworker lottery. Because what I did not know back then was that our immediate connection as coworkers, women, future mothers would transform into a lasting friendship beyond the office hours that has enriched both of our lives in so many wonderful ways. It is indeed my honor to be here today to speak on her behalf and endorse her nomination as Associate Justice of the Probate and Family Court. I met Carla when she was an associate attorney at a Boston firm where I also worked as a paralegal. We worked together on domestic relations matters, but her qualifications for associate justice extend beyond her legal skills and include her compassion, temperament, and empathy. This firm, like many other Boston firms, preferred handling high-end cases. Carla, however, did not always work within these parameters, as I soon saw for myself. I recall a contract dispute case involving a troubled young man who suffered from an opioid addiction. She deviated from the firm norm and usual type of cases and sought permission to bring in the case because it mattered to this man. It was not a lucrative case, but Carla was as committed and dedicated to it as if it was. She knew her work was going to impact the life of this client and was focused. What she did not anticipate was having to manage the client's family dynamics, as the client, who suffered with an addiction, was giving his family a different version of the case status, and in fact, told his father that he was free to speak with Carla, yet would contact Carla to warn her that his father may be calling, and he did not waive the attorney-client privilege, and Carla was precluded from speaking with the father. The result was that the father would leave Carla scathing voicemail messages, sometimes insulting her for not returning his calls. It became clear at that home, Carla was the scapegoat for the fact that the father was in the dark regarding these details. Managing the family dynamics did not deter Carla from her charge, and she continued to focus on the case. When asked whether she intended to withdraw because of this family conflict and the father's messages and behavior, Carla dismissed the idea and empathized with the father's predicament, yet held strong to her ethical obligations to her client. If the father's ranting and insulting messages bothered Carla, I never knew because she just continued to advance the case. It wasn't long before I realized that what Carla was to me, this respected, driven, yet kind and compassionate soul, well, it wasn't just to me. She was all of that and more to others as well. Because Carla treats people just as she does cases. She does not differentiate based on perceived status, titles, or hierarchy. People see this quality about her and are drawn to her because of it, just as I was. She's the type of attorney or kind of person where the evening receptionist felt comfortable stopping into her office and sitting down in a chair to have a friendly chat before her shift started. I did not see this receptionist feel at ease with any other attorneys in that office. Carla would always greet the support staff, and not just with a rhetorical hello. She was sincere and would be certain to ask them follow-up questions about something they previously had shared with her, like their plans for the weekend. I also witnessed Carla counsel an administrative assistant who was visibly upset about an interaction with another attorney. The assistant confided in Carla about her challenges working for a demanding attorney, yet knew Carla not only kept her thoughts in confidence, but gave her excellent advice at how to successfully navigate their working relationship. She makes people feel heard and that what they say matters. She was truly one of a kind in our office, and I know every office that she has encountered since. As I have known Carla for more years than the ages of our oldest children, I'm so grateful for the roots of our friendship and the many branches that have grown and flourished over the years. With each season, we have both encountered storms and sunrises, both personally and professionally. But I know this woman can withstand a storm like no other, with all of the qualities we most admire about her. About 2 years ago, Carla had a medical scare that warranted significant and invasive treatment post-op. The strength that she exhibited throughout her treatment, while juggling her full-time job and a mother of 2 young children, was remarkable. She never wanted sympathy, and when I would check in on her, she always mentioned how fortunate she was to have access to top-notch medical care and how badly she felt for others going through a similar diagnosis that did not have the same experience and support system. I have no doubt she is ready for this new role, and all those who appear before her will benefit from her intellect, compassion, and empathy. Thank you.
Thank you. Any questions? Council Kennedy.
You still a toddler?
I am not.
When did you leave then?
I would say, my daughter's 3, I'd say 11 years ago.
I'm sorry?
11 years ago,
11 years ago, okay.
yes.
So you wouldn't have known my daughter, she wasn't there 11.
What's her name?
Alicia Kennedy.
No.
You know Elena Joyce?
That was Carla's secretary, and she sat right outside my office.
You know what she did before she was at Todd and Weld?
I do not.
She was my secretary for 20 years.
Oh, It's a very small world. I loved her. She was very sweet.
Part of my family.
Oh, really? Okay.
Be your testimony.
Thank you. Any other questions?
Council Ferrara.
Thank you. Thank you for appearing. I was going to ask you about Tata
Yes.
the great love. So what do you do now?
So right now I work for a startup medical equipment company, and I'm a case manager. So I have some legal background with doing some medical things. But prior to that, I went to other law firms, divorce, paralegal work.
I had read about the medical issues, and I have a family members going through the same thing. So I appreciate you mentioning that and how hard she fought through it, and with 2 children. It's amazing.
I think that it's something that's one of her strongest qualities and characteristics to date, and she's uncomfortable sharing those things, but I had to bring it in somehow. So thank you.
She has a big fan in Councilor Chris Iannella, who's been twisting our arms. Do you know Councilor Iannella?
I do not.
Right, he's a good guy, and unfortunately, he had something to attend to, but he's a big fan, so that means a lot to me.
Oh, great.
Thank you for coming today.
Thanks for having me.
Thank you.
Well, you were a paralegal,
Yes.
so you see this, did you see the nominee every day? Did you work with her on a regular basis?
So we worked, I saw her every day for sure. I saw her on a regular basis. We had cases that overlapped together, yes.
So you were in an office together? Or?
No. No, at one point she was in my hallway, and then a different time her office moved a little bit. But I did see her every day for sure.
So how would you describe her temperament?
Carla is very calm, cool, and collected. You never really saw her. She doesn't get overly excited. She doesn't get angry. I think that I don't mean to repeat myself, but she's just very even keeled. I could call her and tell her the most shocking thing, and she would have the same tone of voice as if I told her it was the most exciting day of my life, or she's just very steady.
So how long have you known this nominee?
I have known her for 16 years.
So you do know her?
I do, and I had to think about it, but it's my daughter. I go by my daughter's birthday, and then so yes, we were at each other's weddings. And
That's what the council likes to have witnesses that really know professionally and personally.
for sure.
That's wonderful.
Yes, thank you.
Thank you for your testimony.
Thank you.
So that completes the witness list. So is there anyone here in opposition? Hearing none.
It's the second witness.
Now it'll be, excuse me. Oh, I'm sorry, Erin Harris. I didn't mean this. I am so sorry, Erin.
Hey, if you'd like to move to
This is a formal law partner and friend. Shame on me. I'm sorry.
good afternoon, counselors. Thank you for giving me the time to talk to you a little bit today about my colleague, former partner, and good friend, Carla Salvucci. I first met Carla, I believe, 14 years ago. I don't want to date us too much, but we had both just left mid-sized firms and we're starting our own practice, and we wound up subletting office space together in Fort Point. Maybe you would be better terming it as subletting closet space, but that's where we started off. We both were solo practitioners for the first time, and we're having probate and family court cases, some restraining orders, some criminal, some general civil litigation. You know, as most newer attorneys do, you do what you got to do to survive and learn and grow in a practice. And we did that side by side. I'm proud to say that she became not just a colleague, but a friend. As a probate and family court practitioner, people have really different philosophies and approaches to practice. And Carla really was someone I admired and respected for hers. The trial court is based on an adversarial system, and we are zealous advocates for our clients, but we aren't adversaries as attorneys. You know, we have to be professional and respectful of one another. And Carla truly embraced that and embodied it. It's something that I always admired and aspired to as someone who worked side by side with her. Over the years, she really honed her practice down to the probate and family court area, and my practice sort of diverged away from probate and family court and more towards criminal and restraining orders and where those intersected with probate and family court. But for the two of us, we got along well both professionally and personally, and we decided to form a practice together. When you do that as an attorney, your reputation becomes intrinsically tied to your partner. And in the trial court and the legal professional in general, your reputation is everything. So undertaking a partnership with Carla for me was a really big deal. And for me, standing by her side was something that I was proud of. And I was proud of it because of who she was professionally. You all have her resume, and you can see that academically, she was a very gifted student, and professionally, she was very gifted as well. But personally, she is a fundamentally good person, and I was proud to have her as my partner. So as a partner, she was someone I entrusted my friends and family to be represented by when I couldn't do it myself. If I couldn't be in court and I needed someone to stand in for me and to advocate fiercely for my clients, that was Carla who did so. If I was facing a professional or ethical dilemma and I needed information and I needed advice, and sometimes, that advice can be hard to give, she was the person that I went to. And as small practitioners, you surround yourself with other attorneys who are similarly situated because you collectively know more than you do as individuals. So within our circle of solo attorneys and small practitioners, Carla was someone that everyone called upon when they needed help and they needed advice. And you need to know what she did when they called her. She gave them wonderful advice and information. And she was so generous with her time, even when people maybe went a little overboard in their requests for help from her. So that just really says a lot about who she is as an attorney and as a person. For me personally, she went above and beyond as a colleague and as a friend. As women in the profession, it can be very challenging. You face a lot of adversity. And as mothers, as solo practitioners, there is no paid maternity leave. We were one another's backup when we had children, when we went through, as you heard, some health challenges. She was always there for me, both personally and professionally. Just so you know, one example, I was having one of my worst days of motherhood, probably about 6 weeks after I went back to work after having a C-section. And it was his second week in daycare, and he got sent home with a stomach bug. And he had just been sick everywhere. I told Carla what was happening, and she covered for me in court. But the next day, she had a cleaning service at my house to help deal with the aftermath with no questions asked. That level of compassion that she showed me in one of my hardest moments professionally and personally just tells you a lot about who she is as a person. And I believe when she takes the bench, and I'm confident she will, I think you all will make the right decision. She will show that same level of care and compassion to the mothers and fathers who are appearing before her in court, giving them an opportunity to feel like they were treated fairly and adequately included in the process, so that when they get her decision, which I know will be well-reasoned and rational, that they will be able to accept it because of the wonderful way they were treated in her court. So thank you.
Well, your testimony was from your heart. You didn't need a note. Right. I'm going to call on Councilor Duff.
Thank you.
He hasn't given her.
Want to let her give her statement?
Oh,
Normally, he hasn't.
Question.
oh, I am so sorry. Okay.
I had a question.
Hmm?
Do you not have questions for the witness?
I'm asking Annie if she has any questions for this. I'm sorry, what did you say? I don't understand. What did you want?
The nominee didn't give her a statement yet. You were calling on her to ask questions.
Calling on me to ask the nominee for questions.
No, I'm asking you to ask her witness.
Questions I didn't answer.
Okay, thank you.
I just,
Okay.
are you still practicing?
So we ended our practice about, I think it's 2 years ago, when I left to join the executive office as the Access to Justice Coordinator of the trial court. Executive officer.
That goes right to my question of what.
So it was a tough decision, and that's where we diverged, and she was very supportive of my decision to make that change.
Okay, that's all I wanted to understand.
I'm sorry, misspoke. Witness. Anyone else have any questions? Can you tell me how many years you worked together?
I think it's we've known each other about 14, and I left about 2 years ago. So some of that time was in a partnership and some of it was informal, sharing office space and working together as colleagues. But as partners, I want to say 7 to 8 years. I'd have to double check. It all blends together, but.
Could you tell counsel, is there any particular case that really impressed you about her, I don't know, just her demeanor and how she handled it? Is there anything that comes to mind?
So It's one in which I brought her on as co-counsel, and it's right before we started our practice together. It was the most challenging client I had taken on as a professional. The red flags were there, and I didn't see them as a new attorney, and I undertook that case anyways. And the majority of my efforts on the case went towards client management, but we had an uphill battle in the probate and family court that we were facing, and I needed some help, so I brought Carla on. She can teach a masterclass in dealing with challenging litigants. There was a father who was, facing the battle of his life, custody of his children, and at times his own emotions about the process got in the way of our ability to effectively and efficiently advocate for him. She would handle it with such grace. I would say she slows down. When the more upset someone gets, the more she slows down, and she drops the volume of her voice. And she really draws you in with her own calmness and her own demeanor in such a way that you start emulating what she is doing as well. And I've really seen her just through her own body language, her own tone of voice, really just calm our own clients down and opposing parties down, get them to she acknowledges their hurt and their feelings, but then gets them beyond it to the point where we can practically approach the case and move forward with what we need to do to get them the results that they want. Because sometimes clients are their own worst enemies, or opposing litigants can be their own worst enemies when it doesn't benefit them or get them where they need to be. And she did an exceptional job at it, and I will say I learned a lot from her, just watching her and trying to, emulate what she did.
Well, I have to tell you, I've been here a lot of years, this is the most heartfelt testimony, don't you think, councils, really? And it means a lot to us. And so that has completed your witness list. And I already asked if there was anyone in opposition, and there isn't. Now, is there anyone that would like to speak for this nominee who would like to say something? I welcome you. Anybody? Okay, having said that, now it's your turn for your presentation.
Good afternoon. Governor Maura Healey, Lieutenant Governor Kimberly Driscoll, thank you for the honor of the nomination and the opportunity today. Thank you to the members of the Governor's Council for your time and consideration today. I especially want to thank my host counselor, Marilyn Petito Deavney, not just for shepherding me through this process, but also for the compassion with which you serve. To Valerie McCarthy and her staff, thank you for all your hard work and efforts. My sincere gratitude to Chief Legal Counsel H. Scott Reed and Deputy Legal Counsel Dara Kesselheim. Your assistance during this process has been invaluable, and I appreciate the thought-provoking questions during my interview. To members of the Judicial Nominating Committee, thank you for your time and dedication. The time you commit to the nomination process is commendable. I would be remiss if I didn't thank my family for their support through the years, as well as Tracy Cohen and Erin Harris for your time today. And last, a special note of gratitude to my husband and especially my children for encouraging me through this process and at times believing in me more than I did myself. Daughter, sister, wife, mother, attorney, advocate, and friend. In the simplest terms, these are the words that best describe me. On May 22nd, I had the distinct honor of adding nominee for Associate Justice of the Probate and Family Court to that list. However, it is my experiences from the original list that I believe qualify me to transition from nominee to Associate Justice. I was born and raised in Waltham, Massachusetts. I am the proud daughter of Italian immigrants. At 19 years old, my father and his parents left family in Italy and immigrated to the United States. He first arrived in New York, where he worked as a mason. Coming from a tiny village, New York proved to be too overwhelming, and eventually his parents relocated to Nonantum, a neighborhood in Newton, Massachusetts that was heavily populated with Italian immigrants, most from the same village as him. Without knowledge of the English language or higher education, my father used his greatest asset at the time, his hands, to provide for himself and his widowed grandmother, who cleaned hospital rooms. My widowed grandmother who cleaned hospital rooms. Despite the absence of degrees from distinguished universities on the wall and a strong Italian accent that some may label as broken English, my father is one of the most capable and intelligent people I know. He believed in himself and started his own construction company. More than 50 years later, the walls of his office are covered with awards for outstanding craftsmanship and, more proudly, letters of appreciation for his philanthropy. My mother immigrated to the U.S. when she was 4 years old. She and my grandparents lived in Watertown. My grandfather, also a tradesperson, was a plasterer and worked well past the age of retirement until the shoulder was so worn he could no longer work. My grandmother, who I'm still blessed to have in my life, she's now 97 years old, worked in a factory soldering metals. She tried retirement but was restless with so much time on her hands, and in her 70s returned to work at a wholesale club where she distributed food samples until her official retirement in her late 80s. She continues to enrich my family's world and is insulted when people suggest that she needs assistance. Although my parents came from neighboring villages in Italy, they met in Dedham, Massachusetts, eventually married, and started the family I'm so blessed to have with me today. There were 4 of us: my mother, father, sister, and me. My sister is also an attorney who has focused her talents on business and public education, where she served as a member of her town's school committee for 9 years. My family instilled a strong work ethic in me. My father worked long and hard hours, and my mother supported him, not just by parenting, but also by keeping the books. She ensured that clients were invoiced and suppliers were paid timely, because there was no line of credit, and if there was, we didn't qualify for it at the time. My parents worked tirelessly to provide my sister and I with opportunities they never had. First college and then law school. And as importantly, they taught us to be charitable, to help those in need by being generous with our time and when possible, money. For this reason, my sister and I have established a scholarship in their honor for first-generation law students like us. Growing up in an immigrant family is a unique experience. At times, my sister and I could not look to our parents for guidance because the situation was as new to them as it was for us. In these circumstances, she and I had to navigate our own way and then attempt to explain the significance of some social norm to our parents. She and I had not yet honed our advocacy skills because many times, no matter how hard we tried to explain things, they could not understand why we would want to sleep on the floor of a friend's house when we had perfectly good beds. They couldn't understand why we begged for sneakers when we had beautiful leather shoes that my grandmother proudly bought in the North End. And if we asked for a bologna or a PB&J sandwich for lunch because the scents and appearance of our foods prompted ridicule from classmates, it wouldn't even warrant a response. Again, our experience was different from most of our peers, and that of course is okay, but I didn't always believe so. During my teens, my family, including my maternal grandmother, went out for a hibachi dinner. It should have been a special evening, but it wasn't. The 5 of us shared a table with a young couple. During the dinner, we talked amongst ourselves, and our conversation varied between Italian and English, sometimes even mid-sentence. As we were leaving the restaurant, the same couple drove by, rolled down the passenger side window, and shouted a derogatory name for Italians at us. At that time, I felt ashamed and embarrassed. I wasted hours trying to figure out what warranted the comment so that perhaps I could fix whatever it was. I had forgotten about the incident until recently when I helped my son navigate a similar situation and realized that that hibachi experience helped shape me into the person I am today and possibly the associate justice I hope to be. I learned that words have impact far beyond their definition and that people should not be made to feel less than because of another's words or actions. For all intents and purposes, it taught me empathy long before I learned the term. It taught me to accept others for who they are, appreciate cultural differences, and interact with people in a way that makes them feel valued and heard. In treating others that way, it enabled me to appreciate my own history and culture and realize there was nothing wrong with that teen and family at the hibachi dinner. My professional career started as a consultant. I worked long hours, and while I wasn't adverse to hard work, I was not passionate about what I did. For a period, and partially inspired by Robin Williams' character in Good Will Hunting, I considered social work. But during graduate school, quickly learned I wasn't suited to be a clinical social worker. I was too attached and impacted by others' stories and hardships, and perpetually frustrated that I couldn't make things right for them. In law school, I realized I was better suited to counsel clients on how to legally change their circumstances and gravitated towards family law. I revel in helping people through what they often consider their darkest time and restoring a sense of calm to their world, a chance to reset and start fresh. Through the years, I had the privilege of working with several excellent attorneys who formally or informally mentored and motivated me and inspired me to do my best. However, it was my clients and their adversaries who helped hone my interpersonal skills and temperament. My clients have demonstrated that there is no one-size-fits-all approach when it comes to families and the approach to servicing them. They came from various social, economic, and cultural backgrounds. Some suffered from physical abuse, others from addiction, and still others mental health issues. I have experienced the challenges and managed clients' frustrations when dealing with a self-represented adversary. Having to explain that assisting a self-represented ex-spouse with procedure is not working for the other side and actually will benefit both parties in the process. Each client has aided in my personal and professional development, and I'm grateful for the opportunities and for their trust. As an attorney, I place significant value in understanding clients' experiences, culture, and the circumstances that have shaped their lives. Such understanding enables me to better advocate on their behalf and consider alternative strategies. Empathy and listening are paramount and provide insight, which is essential when attempting to determine best interests of the child and what is equitable. As a judge in the probate and family court, I will be fair and impartial, and as importantly, work to ensure that I consider the parties' circumstances and experiences, make them feel heard, and for self-represented litigants, ensure they have access to resources so that I can impartially judge based on the merits, not on procedural advantages of the represented litigant. I maintain that these measures will instill equity and confidence in the judicial process among both litigants and counsel. And with your support, I welcome the opportunity to do so. Thank you for your consideration today.
Thank you. The procedure is I would be calling on Counselor Ferrara. Since he's not here, I will call on Counselor Duff.
In Italy, is your father from?
Question. My father is from the village of San Donato Valcomino. It's in the region of Lazio in the province of Frosinone.
Just wondering if my family's in Italy. Okay, great. We know a lot from what you just told us and from your resume. What experience do you have working with the LGBTQ community?
So I don't have any direct experience as clients, but one of my clients' daughter was suffering from gender identity issues. And during that process, I was representing him in a modification because there was a lot going on between the child and mother as well as him. Ultimately, he terminated me from representation, but we reconnected afterwards, and I was happy to hear that he supported her efforts as she was figuring out her gender identity.
That's great. Because, you know, one of the issues that when we won equal marriage, we also won the right to get divorced. And so I tell you, don't be careful what you wish for sometimes, right? And that will be an issue in the courts that you will deal with. And some of it will be complex. It's the same, but there is some slight differences. And I just was wondering, you have no experience working with those clients? Have you ever represented any gay or lesbian people that were married?
I have represented gay clients in their prenuptial agreements.
Great. What do you think would be your biggest challenge in the court if you ascend to the bench?
I think the biggest challenge would be ensuring that everybody has access and equitable access to the resources available to them. I think that it's ensuring that litigants know that it's there and that they can access them.
So by that, do you mean like lawyer of the day? Because you're going to see pro se things. And as you know, one of the things that I'm keeping up on a lot right now is, and it's interesting because AI, okay, so we know there was someone who filed a brief on February 12th using AI, which cited all kinds of false law. But LexisNexis has literally just rolled out an amazing version of AI. And I don't know if you've seen it or you're using it yet. That would be great for the law. If pro se litigants had it, it's an incredibly powerful tool. The more expensive AIs are phenomenal. And one of my concerns is how, if you have a couple, a man and a woman divorcing, and one of them works with a firm that has access to that, and the other one does not, or the other one is a pro se litigant. How do you, I mean, can you do it? But you might not necessarily know. This is a whole new world that we're going into, because the power of this technology can level the playing field, but it can really make it more balanced. And the bigger the firm, the more risks in that. But have you given this any thought or consideration?
I have not given it thought and consideration. However, in thinking about it here today, I think that we tend to forget that at the courthouses, there are court libraries, and there's resources there, and the librarians are very well versed in finding this information. And I think that as an initial response to this and a quick fix, I think that probably directing litigants that may need some assistance to those court libraries to request time with the librarians would be helpful.
That's a great piece of information. I'm not an attorney, and I wouldn't, when I'm in court for things, I'm a realtor, I'm dealing with other types of issues. But, so if you did that, this is not a trick question. I'm really curious because I don't know the answer. If you did that, do they have LexisNexis in the court libraries? Do they have public access to that?
I have not used the libraries myself, but I believe that there's access to it, whether it's not, because I know that the social law library has access to it, so I'm presuming that it's at the trial courthouses as well.
Because this is an extra charge on top of your regular subscription to it. So I'm just curious, and I don't know, I'm gonna guess with Commonwealth's budget, they're not gonna have it. But I'm just bringing it up. This is the new world. We're in a whole new world. And talking to, some of the judges in the appeals court and Supreme Judicial Court, there are whole committees studying this right now. The great versions of AI, like the really great legal versions, cost $1 million a year. So those are probably only the really elite firms. We're talking about the MOFOs. This is like a whole new world. And I don't know that it's going to impact us in a Massachusetts probate court at all. But I do think it's imperative for us, those of us that sitting in this room and those of us who may be sitting on the bench, to be really aware of this. Because like I said, this technology can be really, really great, but it could really shift things. You're nodding your head. I mean, it can level the playing field, or it can throw us into something that's so uneven. And you're a judge, so you can't really help them if they're there as a pro se litigant. I mean, you might be able to give them some guidance and things, but anyway, that's all I have for you. Thank you very much for applying. Appreciate it. Thank you.
Thank you. Counselor Kennedy,
Thank you, Madam Chair.
your name is upside down.
Is your daughter over there?
No, that's
I know it's not.
No?
my daughter's right there.
Is that your daughter there?
Yes.
Does she know that from now on at home, she's gonna have to call you Your Honor?
A big smile there. I'm not sure how she feels.
I have a few questions, not many. Before I start though, I want to point out two folks that are huge fans of yours. One is someone who had to leave because he had a prior commitment, but a very Council Iannello, I've had the privilege of serving with for 14 years.
Excuse me. Aaron, can you show the councils who are speaking? People at home would like to see them. Who's speaking?
Anyway, but Chris is a huge fan. Is all over me about wouldn't be here today because of a prior commitment. I want to point that out. I also got a call from one of my closest friends in the world, Peter Belani, who said that you were, I've been friends for 40 years, speak almost daily. And he had a lot of good things to say about you. That said, I do have a couple of questions. Okay. It's past my bedtime. But anyway, I want to talk a little bit about women in the law. Do you think women get on a playing field in the law with men?
I think there's the appearance that there's equal. I think there's the appearance that the playing field is equal, but in practice, I think women have, because they are able to give birth and they have maternity leave and they have some physical challenges that men don't have when it comes to
Sure.
childbirth. So I think that that would deter us from having equal playing field.
That's really important, and that definitely affects that. But let's take that aside for a moment. Just in general, when you have, women going for partners, men going for partners, do you think they're on firms, do you think they're on an equal playing field?
Well, I'm not in the room to make those decisions and to evaluate the male versus female associates of the firm that are up for the partnership. So unfortunately, I can't answer that.
I don't think they are. Even in this day and age, as sad as it is to say, I think we have challenges. I think it's very subtle today. It's not overt like it used to be. But I think there's still a lot of discrimination there, and that's very troubling. Anyway, I am really, really impressed with the depth of your experience. It is really incredible. You've been doing this for a long time, for someone as young as you are. Trust me, I've been doing it 40 years. You're very young. Okay? I think you're going to be a terrific judge in the probate court. I think even when you become a judge, you're still going to deal with some of those issues. And I think that's sad even in this day and age. If I didn't vote for you next week, I think Ianella would break both my arms. So I ain't going to vote for you. And I think you'll be a terrific judge. Thank you, madam.
Thank you. Counsel.
Thank you, Madam Chair. Good afternoon.
Good afternoon.
Your counselor, Chris Ianella, is a very adamant supporter of yours. I'm going to let that out there. I spent a couple years living in the lake. I listened to your family's story, found it very compelling. I do have a couple questions for you. One is starting with something Counselor Duff brought up. So it wasn't our probate courts, but in Massachusetts, our courts open the floodgates for same-sex marriage, really in the country and beyond. It's important to me that our courts continue to be fair-minded and impartial and not accounting for someone's sexuality or sexual identity when justice is being dispersed. And I know that our government has actively, reached out to people in other states where there's a feeling where they're not as welcome to come on to Massachusetts. We're a welcoming place. Do you feel that's your approach as a potential probate judge?
To welcome people into the courtroom?
I think that, is there any circumstance to take into account someone's sexual orientation?
I think that people and families come in all different shapes and sizes, and people are welcome to get married. And in law school, I actually was on the Lambda student group, and I advocated as an ally on behalf of the LGBTQ community. And at that time, marriage was illegal in Massachusetts, but we were advocating for the passage of same-sex marriage.
I'm glad to hear that. I've worked with children who've been rejected by their families and end up on the street because of their sexual orientation. And it scares me to see things that are happening in some other states, but I'm grateful to know that Massachusetts continues to be a welcoming place. So I was impressed that you were initially interested in social work. And there was a lot of talk in your application and from your witnesses about your patience. And I'm wondering, what would be your threshold to hold someone in contempt in your court?
Did I show up?
That's an easy one. Is there another one?
That's a good question. I think continued violations of the court orders would probably be it. And I'm not talking, if there's a contempt and there's an order either to pay or to follow an order, and then it hasn't been met even after the initial contempt, then I probably would hold somebody in contempt of court. It would take a little bit, but I have to be mindful that even though I'm patient, there are families on the other side that are waiting for some sort of action. And maybe it won't behoove them for me to be totally patient because things have to move. There's families that need to be fed, there's families that need to receive support, and there's children that may need time with parents.
I think our probate courts do a great job. I think they're in need of more judges. That's why we have more coming. But from time to time, folks who've experienced the courts come with me with their personal anecdotes and concerns, and those kind of add up in my head over time. So I just want to hear your perspective on a couple things. Around abuse prevention orders, and alleged abuse of any kind in general that might come in the court. I've talked to folks who say they've been put into the same space with their alleged abuser for conferencing in the courtrooms, in the courthouse. Do you think that's appropriate? Should that happen? That concerns me, and I'm not sure that it's pervasive, but I would like to make sure it doesn't happen.
That's a good question. I haven't had that experience. In fact, it had quite the opposite, where everybody in the courthouse, from the court officers to the attorneys, are very mindful if there's a abuse prevention order in place, and no one sits in the same room. In fact, don't even sit in the gallery together. Somebody's outside of the courtroom. I would continue to make sure that that is the case. Like I said, that's foreign to me. I think that's the exception and not the norm.
I agree. I think what you described is how we generally operate, but it's comforting, I think, for some people to hear that that's our continued approach. Same question regarding co-parenting classes. I've spoken to folks who tell me they've been put into co-parenting classes with their alleged abuser or the alleged abuser of their children. I don't think that's how things operate. Is that anything you've experienced or never think is appropriate?
I do not think that that would be appropriate. I think that if a parenting class is mandated, then it should be part of the intake, and they should have separate classes. They shouldn't be in the same room.
I'm glad to hear that. Again, I know that our courts do a great job. You're right. But when folks, or even if they're perceiving the experience like that, it's important we stay on top of it. I appreciate your answer. Finally, you've been reading some of the novels you read in your teenage years. You said you've been finding new subtleties and insights. Is there anyone in particular that you'd like to share? I'd love to hear how your insights have expanded over time.
Two, in particular, Old Man in the Sea and A Tree Grows in Brooklyn.
Okay.
Francie Nolan is a particularly interesting character. I didn't understand how deep she was when I read it in high school, but I recently read it in the past 2 years. And she was parentified based on the addiction issues in her family, and she was a very strong woman, and I admired her and her mother for their strength. And I think that the feminist side of that was lost on me in high school, so I had a different appreciation as an adult. And then Old Man in the Sea, my husband and son have been into fishing, so I decided to pull that book off the shelf. And I enjoyed it more now than I did in high school. Just the perseverance of this individual and the strength of this man when he was being mocked, but he continued to just persevere. And all he had to do is walk off the boat with the carcass of the fish, and nothing else needed to be said. So I really enjoyed that.
Thank you for indulging that question. I have a lot of confidence you're going to have a lot of empathy on the bench. I appreciate your time. Thank you, Counselor.
Thank you. Counselor.
That's good to see you. Thank you for coming out and chatting with me. Feels like it was forever ago, but maybe it was a week ago. So why do you want to be a judge?
Want to be a judge because I want to help people. I think that I've done what I could as an attorney, and I've enjoyed the time counseling people, but I feel that I can only get so far. So I can advocate, I can advise, but I can't actually affect change, and that if I were to sit on the bench, I can actually affect the change that I had hoped.
What kind of change are you thinking of?
Well, it's helping parties. I won't always, obviously, people won't be satisfied with my decision, but when confronted with a problem, instead of bringing litigants to the bench and advocating for their behalf, it's helping them or making the decision based on the facts and circumstances of the case, and finally making a decision based on what's before me versus just advocating for it.
Fair. So I have a couple questions. Just I want to understand your experience a little better, because I think we talked about this briefly when we sat down, but I had noticed in your application that you referenced the same cases multiple times. In one instance, there were 3 cases you repeated, and in one instance, 3 times you used it for various sections of the application. And as the newest member here, it's the first time I've seen an application that did that. So I want to understand from your perspective why you feel ready to take the bench and what you believe your areas where you might have a learning curve might be.
So, thank you for the inquiry and the opportunity to explain. So a lot of the cases that were referenced multiple times is because the questions were specific in asking about trial experience. And unfortunately, because of the cost of litigation is so high, going to trial becomes cost prohibitive to most clients. And they'll settle far short of going to trial. So when the questions asked about trials, I had to limit it to the experiences that I did have.
And I think I saw in your application, you've had 6 actually go to trial.
Yes.
Over the course of how many years?
Since 2003. So 21 years.
And the last trial was in 2016.
My last trial was 2016, and it was a removal trial. And that was the first trial and only trial that I had at my firm when I went on my own. And so, to be honest with you, that's one of my greatest accomplishments, because I wasn't at a firm, I was on my own, and it was a 2-day trial involving a very difficult subject matter as well as a guardian ad litem. And I was really proud of that, and I was happy that my client was able to relocate with her new spouse and her daughter. Regarding the learning curve question, I think the learning curve I'm going to have is going to be in the probate side of the court, probate administration and will contests. But I am confident that the resources available to me to learn the subject matter, colleagues, and the advocacy of the attorneys, I will be able to figure it out.
Thank you for that. So I would like to hear about your experience as a bar advocate. You listed that you did that for a year.
I did do that. I did it for a year because my partner, Erin Harris, specialized in criminal defense work. And when we would collaborate, I really enjoyed listening to her experiences. So I applied and had a 1-year contract with Suffolk Lawyers for Justice. I did it and I enjoyed the opportunity, but it wasn't for me. I think similar to how I responded to people in social work, it seemed that sometimes the defendants were a little defeated and they didn't want to fight for opportunities, and they would just take a plea that was offered to them. And that's fine, that was their choice. But as an attorney, it wasn't an area of practice that I jived with.
Fair enough. I think having the experience and seeing what works for you and what doesn't, right? I appreciate that Councillor Duff, and actually Councillor DiPaolo as well raised the question around the LGBTQ. I was going to delve in on that, and I think they've covered it to my satisfaction. I'm curious about your thoughts around, especially given what's happening nationally around abortion access. And I don't know how often it actually is relevant, although some of the in some divorce situations, abortion can be a driving factor around, divided desire for children and break a marriage apart. So it will be relevant in the probate and family court that might come before you, but I just wanted to understand where you stand.
Well, I don't think it matters respectfully where I stand. I think it matters where the litigants stand, in the sense that these are 2 adults and there is a woman that's making a choice, and it's her choice to make. And if it leads to a deterioration of their marriage, that's where I can assist. I don't think that there's a situation where a litigant would be seeking an abortion in Massachusetts. They can get their abortion. So other than a child, but I believe that goes to the Superior Court. So I don't think it's something that would confront me.
No, I was thinking it might be more relevant for probate and family where in fully adults. Not a situation where parents are trying to prevent a minor, but in, So, but just to put it bluntly, you support a woman's right to choose.
I believe a woman has a right to choose.
Is there any area where you think you do have work to do around your own personal biases that might impact you on the court?
Of course, we all have biases, whether or not. That's a really interesting question. Thank you for asking. In terms of any biases that I have, I don't think that I would have it at sitting on the bench because I understand, right, that both parties and both litigants have issues. I've represented the alcoholic, the parent that suffers from alcoholism. And I've advocated for him fully understanding, and I was conflicted that there's also a mother and children that are suffering because of his disease. So in terms of biases, I don't think that if I see them at the time, I think I'd be mindful enough to be able to table them and focus on the issues before me.
Kind of stick to the facts of the case. That's what you're saying.
Excellent.
All right, listen, I appreciate you answering my questions. You know what, I did have one more before I close. I did have one more. So there's in your application, you talked about I'm just gonna quote you. I'm gonna quote you to you. So having children has enlightened my understanding of the best interests of the child standard and how a parenting plan that seems reasonable in theory may not be in the child's best interest in practice. And then you go on to say more, but I'm not gonna read more than that. But I just want to understand sort of how you would approach that from the focus on the interest of the child when you potentially, like, what criteria would you use in evaluating a parenting plan and potentially divert from as presented?
Thank you for asking. This is what I would do, and I've seen it done from the bench, is when you read the parenting plan, specifically ask counsel and or the litigants the situation that comes to mind. So for instance, whether it's going to be every other day, does that mean the child's going to have, a set of books at home? I mean, I would ask a specific question so that it could be thought-provoking and they could understand that while a plan looks like Monday and Friday or whatever it might be, that there's actual real challenges. And I'd probably raise some things that they may not be thinking about, but with experience, you've seen it. And in fact, I still do it with my clients now. And I say, I hear what you're saying and I see this, but I need you to think about X, Y, and Z because I've seen it become an issue in other cases. And with that said, if they choose to go forward with it, then it's their choice.
I appreciate it. Thank you very much for answering my questions. That's the only questions I have today.
Well, I want to thank you for all the time that you afforded me. And the thing that I'm concerned about is, and I don't know how many cases that you had that you found that maybe looking back, it could have been different or whatever. I'm going to tell you why I'm so concerned, especially. The counselors, the Duff who was here, and Counselor DePaula, and Counselor Tara, were not on the council this time. This was in my early years. And the nominee was on the probate court. And he had a removal case. And the father was very dedicated to the children. They were young, they were toddlers. And he lived near there after the divorce where she lived with the children. And he saw them nearly every day and was involved in all their activities. And even Christmas Eve, he'd come over and stay overnight in the morning when they opened the presents. So she went to court asking to take her children to Oregon to live. And she did not have a friend there. She didn't have a family member. She didn't know anyone there. She didn't have a job. What would you have done?
So I appreciate the question. I think it's a really challenging because you just described where there's two parents that are interested in their children, but it really does come down to the real advantage to the party that's looking to leave. And depending on the facts of the case would dictate. I don't know if that litigant in the scenario you described had an employment opportunity that was going to make the litigant or the parents' world and the child's world better. So I don't know the cases, but I do know that the standard of the real advantage is important, and that it's a high threshold to remove from Commonwealth. And I would take into account all the factors of the case in making that determination.
So your opinion would be,
I don't think I can opine based on the circumstances you gave me, because all I know is that there's two parties and a spouse that wanted to go to Oregon, but I don't know why that person wanted to go to Oregon.
well, I think it's clear. It was ridiculous, you know, it was, just to keep the children from the father. It was vindictive. And in addition to that, I saw this in the Boston Globe, and when I saw it, I was devastated. And she gave visitation rights, the judge, to the father 1 hour a day on the computer. Do you think that's fair? Do you think that's equal parenting? You know, he couldn't hug a computer. So I just wanted to know how you would feel. What criteria would you use to allow someone to remove a child to go to another state?
So the criteria that I would use would be the real advantage. And then to the extent that it seems that the relocation request is intended or motivated to deprive the child from a relationship with the other parent, that would really be something I'd consider and probably not allow the removal. There has to be a real advantage to the parent. I think you said mother in that case. That would then trickle down to the child. But in terms of visitation, and I'm not trying to be, cute here, I can't answer what kind of visitation I would give because I don't know any circumstances. I don't know if there was.
Very straightforward.
I don't know if there was allegations of a
You just want to
relationship.
children across the country. That's it. But anyway, that is not what I would approve of, because he was a good father, and he'll have no relationship with those children. They will not know their father. And I strongly believe every child deserves to have a relationship with their mother and father on a daily basis, or however often, whatever the work schedule is of the parents. But I think it has to have really, you've had other cases where you have let them move. You talked about one of your cases, a woman from Massachusetts who remarried someone from New Hampshire. And she wanted to move to New Hampshire. And she hadn't been with her new husband for a year because she was in Massachusetts with her child. So it caused some kind of tension between this couple. So you made a decision to allow her to go to New Hampshire with her new husband with the child. But there's nothing here that tells me what the conditions were. What is the rights of the father, the biological father? When does he see the child? It didn't say that. Could you tell me the rest of the story in that case?
Of course. So you're right that both parents have a right to their children and to ideally to foster a relationship with both parents, even once post the dissolution of the marriage. In this case, it was just over the border. So the parenting plan actually would have stayed intact. And it was just a longer commute, a little bit over an hour to maintain the existing parenting plan. So it was really the real advantage to the mother, who was single mother, and financially it was better for her, and she had the support from her new spouse. But in terms of the parenting plan, it wasn't as affected because it was simply over the border, and it just meant a little bit more driving to have the same parenting plan that the father had in Massachusetts.
And you had a case where the child was disabled. Do you look into to see what kind of school? I served on a commission of disabilities for 22 years, so I'm very concerned about that. When a child is moved from one state to another, does the judge look into what kind of school would be appropriate to give the proper education to this child?
I believe the judge did consider it because at the trial, both sides introduced evidence regarding the existing school as well as the school that the child would be attending if allowed to remove to New Hampshire.
Do you like to write? Do you like to write? I liked your sample. Do you want to talk about that, your sample writing that you gave us?
Like me to, yes. I do. Would you like me to?
Would you tell, I read it, but I mean, these people don't know. You want to tell us about it?
So I was asked by a friend of a friend if I would consider representing him in a case that he was bringing against his law school. It was during COVID, and he had, at the time, he was applying to law school, and in making his decision, he had asked the director of admissions whether or not he would have to get vaccinated in order to attend school. And the director of admissions said, if you have a medical reason, then certainly we wouldn't require you to get vaccinated. He was able to attend the first year of law school because it was remote. But then for his second year of law school, it was not remote. Remote was not an option, and you had to be on campus. But to be on campus, you had to take the COVID-19 vaccine, and he refused to take it. Ultimately, he was discharged. He's filed an exemption, and he filed a religious exemption, not a medical exemption. And he kept following up, and he never heard back from the law school. Ultimately, when he went to re-enroll for his classes, he couldn't, and he found out that basically he had been unenrolled from the institution. So we filed a case in Superior Court, and we lost on a motion to dismiss. The judge, I think, it's on appeal, so I don't want to say too much. The litigant is now self-represented, but the point was it was dismissed because when we were talking about breach of contract, the representation was that he would not have to get the COVID vaccine based on a medical exemption, and he sought a religious exemption. So it was a very finite opportunity. I'm proud of that work for a couple of reasons. One, I had recently finished some treatments for my medical issues, and it was the first significant piece of writing that I had, and it was outside of the probate and family court. So it was original. I didn't resurrect a case and revise it, and also it was controversial, and I was hesitant to put my name on something that I knew was not a popular stance in the Commonwealth, but it meant a lot to this litigant. I felt badly for him. He had had a difficult life. And I was proud to say that I was going to represent him because, again, when you advocate for your client, it's based on your own beliefs.
Well, I want to say that you got through your health issues, and we're very pleased with that. I'm very impressed with you, and I like private practice. I think it's great when people work in Attorney General or whatever, but they're given the case. You choose who you want to, and you have chosen people who are poor. Some can't afford a lawyer. You have compassion, and that's what I look for, compassion. And that's what I saw. The other thing is, I just think that when you are sitting on that bench and someone comes in with a lawyer, that person just has to pay a lot of bucks for that lawyer, and that you will be more sensitive. And I don't know how it works. You have to take them in order, but maybe you'll take her first or whatever. But I just think you have to be responsible for paying the rent, shovel the snow. So you have an understanding of the whole process from the lawyer to the person coming in before you. But, and the other thing I want to mention, which doesn't really amount to a lot of people, but it mattered to me, your contributions. You did not give to one elected person in the whole state of Massachusetts, and or you or your husband the last 3 years. And that's what I love about this administration I'm serving with. We're having people come in that are not political insiders. They're qualified. And you did it the old-fashioned way. You're qualified, you're experienced. I like the age. And you came from a family who were working families, and you were on with a silver spoon in your mouth. And that's what I like to see. And I'm very happy that you applied. I'm very happy that the governor has approved. And I'll be looking forward next Wednesday. Oh, next Wednesday we have a holiday. That June is whatever it is, it's a holiday. So we will be meeting, I think it's the 26th, am I correct? The 26th. And we will be meeting with the Lieutenant Governor. She'll have the roll call and she'll call on me and I will be very pleased to put your name in nomination. So I'm going to end this hearing and I thank you all for coming. I really appreciate it.
Very much, we appreciate it.